All right, everybody. I'm going to kick us off because we got a tight schedule here. I'm Vince Joralemon. I'm the director of the Life Sciences Law and Policy Center here, and I work closely with the BCLT. I work within BCLT and closely with the BCLT folks, and we do a lot of. And I was in your shoes not long ago when I was making these decisions about what courses to take. I have a lot of advice to give you. I said this earlier. I'll say it again. We're being recorded, just FYI, so we can post this afterwards. Wayne and I will be here for the 2 o'clock to 3 o'clock period in this room in case anyone wants to stick around and has more ask more personalized questions, because I don't think we're going to have a ton of time for Q&A. All right, just to go over a few things, we have a BCLT certificate that you can get. I'm guessing a lot of the people in this room are going to be interested in this. The requirements are up on our website, but you largely need to take just a certain number of credits under the BCLT umbrella, and then also write a paper on this. I will just note, if you're in this room, you probably are very close to qualifying for this, or you will qualify for this. If you ever have any questions about this, or you're nervous about, oh, I'm not sure if what I wrote qualifies for this, we can work with you. We really like when getting students across the threshold for this. I did it. It was no big problem. Honestly, for me, by the time I graduated, I just had to check a box. Do we have any LLMs in here? I would assume not, because they're not interested in next year. But let them know, if your LLM friends next year, about this. Okay, so I'll really quickly talk about the Law and Technology Writing Workshop with my co-professor coming up. Yeah. Do you want to give a little intro?
You can do it.
Okay. I taught it last. I taught it last fall. We're going to teach it again. I will just note it's a very intense course. You will research and discover and draft and ultimately at the end of one semester have a law review ready student note. It's a lot of work, but I'll just note it's very cool to have a published law review article. I say that as someone who did that when I was here, and it really ended up being worthwhile for me, even though at the time I had no intention of coming back to academia. And it's just really cool to have this difficult thing that is going to be available forever. Once it's published, it has your name on it, and it's cool to just be in the pantheon of legal writing.
Yeah, I mean, so it's really cool to have that law review article, I think, or that student note. I think for students who are really interested or potentially interested in an academic path, or students who wrote a thesis in undergrad and loved doing it, or students that are really interested in honing their research skills in particular, this is a great opportunity. But the thing that I want to emphasize that Vincent already said is that this is not for the faint of heart. It is a hard, intense class. It's 3 units that read like 4.5. And so I just want you to be aware of that and have your eyes open when you enroll in the class. But it is, for me, the single most rewarding thing that I did in law school was write a student note. And my goal in teaching this class next semester is to give you that same experience, that this should be the most rewarding semester that you have in law school.
To that end, if you want to learn more about this, we strongly encourage that you come to our happy hour on Monday. We're going to be at Free House from 4:30 to 5:30. We can discuss more about this, but really, I strongly recommend those who are interested to come to that to learn more about it. But I also strongly recommend, if you commit to this, that you really understand that it is going to be a big time commitment. It is very difficult to write a whole law review article in a semester. And we get this to the point where you are going to be proud of this for the rest of your career. So we really do push you to make something really high quality.
Yeah, and again, it's a lot of work. There's a lot of payoff to that. But also, we're not just going to show up on day one and say, okay, go write an article, and that's it. We're going to walk you through it. There are milestones, there are steps. So we care about writing and scholarship, and so the idea here is to help you through that process of thinking through where you start, what's the research question, what's the methodology for answering it, what's the answer that you get, how do you write it up, make it presentable. So all of those elements are things that we will walk you through and help you with. But again, it's a lot of work.
I'll just note for this class and for a lot of other classes, like we traditionally had an application for this, and we do not have that anymore. Non-clinic classes no longer have any applications. And so that's why we're emphasizing we want to make sure that people are understanding what they're signing up for. That being said, if you're interested, we really hope that you do apply. Happy hour, free house, 4:30 on Monday. Would you like to talk about your AI class? Yeah.
So I'm just going to take 1 second to, since I have this captive audience, to pitch a spring class to you, and I know there's going to be an opportunity to do that later. In the spring, I will be teaching again my Internet and Communications Law class. This is a class that will walk you through how we have regulated telephone, broadcast, cable TV industries, how those regulations have turned into regulations for broadband internet access, and how those systems have basically set the stage for how we regulate platforms, social media companies, app stores. And so the idea behind this class is that we go up the technical stack, we go forward in time. It's another core technology class. We cover the internet, we cover communications law, we cover telephony, and I hope you think about it as you're putting together your schedule, not just for the fall, but for next year, since it'll be on offer in the spring.
Great. All right. We're going to move right along. Speakers, I will just say I shared the schedule earlier, but I'll hold up a little 2-minute sign when we have it, just to keep everything moving. And for anyone who missed it earlier, Wayne and I will stick around after this from 2 to 3 to answer any questions specifically. All right, Wayne.
So on the LTW, the only way using this is to record. On LTWW, I will leave it with this. I taught it for 2 years before Vince took over, and probably the single most transformational class for writing skills I've ever seen. And I've had employers talk to me about they can tell the students that came through that because of the intense mentoring they get. So it is a lot of work. If you didn't catch that, I think they said it 8 times. But the end result is incredible in what it'll do for you. So
You got the clicker right there.
there we go. So for what I'll be teaching next year with Christy from the library is AI in the practice of law. So I've spent the last 6 weeks working with 11 law firms and about 5 different AI vendors to figure out what skill sets are going to be necessary stepping into the practice of law and how that's going to impact you going forward. Law firms are beginning to struggle with AI adoption on how they're teaching, and their number one issue right now is that people coming in don't know anything about how it's being used. When you think about your progression, you're coming through high school, you're coming through undergrad, and even the newest students in this are learning nothing along the way because those institutions are pushing back on AI. And when you step into law school, your first year, legal research, legal writing, they're not AI oriented. So this is probably the 3rd class in your series. After you spend your first 2 semesters, then you're prepped for this. And this is designed for law firm or public interest group practice. So the way it's set up, the way we looked at it, is really to divide this discussion up into what are we really talking about. And there are 3 places that we're seeing AI being rolled out in practice right now. And this won't change over time. Everybody says, oh, it's changing so fast, why even bother? That's not true. It's changing, but the chunks are not changing. On the bottom end, you've got this AI automated. And there are some incredible technologies being rolled out there. They don't need lawyers past the design phase. The ideas around personal injury plaintiffs' lawyers are rapidly changing because those cases are so repeatable and they all look the same. How many car wreck cases are there? How many types? You're looking at half a dozen. So they can develop incredible automated system. The amount of legal work there, the legal new thinking is minimal. And if those all run on contingency, but if you looked at a billable hour rate, that would be a low billable hour rate. On the other end, you get this AI augmented. That's where AI is supposed to expand the capability and capacity of lawyers. And this is the interesting place. This is where the $2,000 an hour lawyers will live and sit. And this is where they're going to be competing with each other. AI is no longer an optional tool. It is actually the tool you need to be competitive with opposing counsel. competitive against someone else pitching the same type of deal work. And that's the piece we're going to focus on, is this AI augmented. The piece in the middle, is continually over your career going to be shifting from left to right. What's AI augmented today will slowly become commoditized over time. You've seen this through generations of legal practice. Expensive work becomes less expensive as it becomes more normalized. So where do you want to be? No one comes to law school to say, I want to be a cheap, poorly paid lawyer. They're on this AI augmented end. And by the way, a lot of the public interest work out there sits on both ends of this. You get the AI augmented, like the Electronic Frontier Foundation, this cutting edge legal work. And then on the other end, you get this AI automated to really bring access to justice to people that just can't afford lawyers anymore. So it's about the difficulty of the work. So what do you end up needing to do? So when working with the firms, we kind of break it down into 3 pieces that are being rolled out into training. Not only here, but I'll be doing a lot of law firm training on this exact issue. You get the efficiency enhancement. 2 things happen with that on high-end lawyers. The things that nobody really enjoys doing, you can automate, get off your plate quickly, basically delegate to an AI system. The creativity enhancement. Now this is the interesting place. How do you think about things, especially as a junior lawyer? How do you expand your own views on an idea? How do you come up with something, how do you know if something's normal, outrageous, or actually really crafty and clever? And that's the creativity enhancement, something AI can do if used correctly. And this is the key piece. And the final piece is capability enhancement. This is, I think, probably the most important piece for high-end legal work. Things that you could technically do before, maybe by hand, you can do now with AI. The things, I'll give you an example. If you want to draft a particular type of brief, well, how do you do it? You get that assignment. Okay, I can look at that partner that gave me the assignment, but what if I can look at 4 of my competitive law firms and see how did they draft this brief? How did they get, what kind of opposition did they draw? What kind of reply brief? What kind of SIR reply? I can look at the entire briefing. I can look at the entire arc of that brief all the way through to final work product. Well, I know that you did not see a lot of this kind of use of other people's briefing. Because why? In law school, we typically focus on results, on the cases. We study the cases, not the arc. The ability to study the arc is actually relatively new. It's only in the last 15 years and maybe 10 years where we could get all of this briefing readily through people like Bloomberg, Docket Navigator. But it's been so expensive to not access but review, never did it. So this gives us this idea around capability enhancement. The old phrase, I can see further because I stand on the shoulders of giants. Well, what if I can look at 20 giants and then properly query against those processes? How did they apply the case? What context did they use? How did they get opposed? Did they misinterpret a case? Did they push it too far? You'll be able to see that in a faster fashion. And I think the great benefit of that is for younger lawyers, you should have an advantage on mentoring over people my generation. I was stuck with one mentor. I happen to have one really good mentor. But a lot of the legal path is dictated by how good your mentor is and what kind of documents your mentor was turning out. Well, now you can see everybody's. It should push us all to actually turn out higher quality work than we could ever do before at a more junior level. So when you hear about these descriptions that AI is going to wreck junior lawyers, it can actually build up those that are industrious and know how to use AI correctly. So I think there's a path forward. I'm not all doom and gloom on that. If you're on the other end of that spectrum doing efficiency-based work, you could be in trouble. But for high-end lawyers, there's going to be a lot there. And you think about how do you organize a class like this. 2 professors wrote a wonderful, wonderful framework for evaluating AI and AI usage. Anthropic picked it up as the core of their teaching on how to responsibly use AI. And it's this framework, they call it the 4Ds. The funny thing about the 4Ds is that it has nothing to do with AI. This is just good management skill. Delegation, who are you going to give the work to? Well, it used to be people. Now it's people plus AI agents. Description, how do you tell people to do the job? What do? You will inevitably be given a job by some partner that says, draft me a brief on this. They will not give you the right context. They will not give you the right facts. They're in a hurry to go do something else. They give poor description. AI will punish you immediately for not giving good description. But it's no different than managing a person. You're just managing AI. Claude in this particular example that we'll use. Discernment, that's the legal analysis. That's where you really apply your understanding and what you have to fill in. This is the piece, again, no different than anybody that ever drafted a brief for me. I've got to understand it. I've got to know what's there. So every project you should do has got discernment built into it. So if you're just asking it to draft me a memo on X case and you haven't done the homework, you can't do the discernment stage. And that's where most law firms are pushing back hard on AI right now, is that people are using AI as a shortcut, not as an enhancement. The final, diligence. This is my favorite in the simplest of them all. Everybody's read the cases about hallucination, lawyers being sanctioned, ethical issues. I've probably supervised 500-700 briefs over my career. Never once saw a hallucination. Why? Because every associate that worked for me checked the sites beforehand. It's actually inconceivable to me that these hallucinations happen. As a judge, I'd probably be harsher than some of the judges that are out there, but now judges are just referring people for ethics violations immediately because it's so easy to fix hallucinations. The thing that's not easy to fix is loss of context. The number one mistake I've seen through my career is somebody goes and finds a quote that fits the brief perfectly. And that used to be hard. You had to search a lot of cases. Now you can find that quote with just a few strokes. And you put that quote in, you don't read the case, and the result of the case is opposite of what needs to happen. That is the biggest issue on the context. So that is now kind of under the diligence piece, and it should be wrapped in with this discernment. And you take these four things across the class, that's what we're going to go through. It's an 11 assignment class, spread over the 14 weeks, all hands-on, no exam, but every week it's a matter of using different portions of the AI system to test different skill sets and develop different skill sets across these issues. And like I said, developed 100% with law firms and what they're seeing and what they're doing, and including with Anthropic and vendors. Now, you're going to be seeing other law schools, other people pushing on things called like vibe coding and trying to build legal tools. Great. No law firm is ever going to let you, as a junior attorney, build your own products, load your own client confidential information in there without having it vetted. And if your billing rate's $800 an hour, no law firm is going to move you over into that. Instead, if you understand these techniques, you can then instruct people that are building systems to design systems for you. But at the front end, you got to understand what you're doing. So with that in mind, if you have any questions, you can talk to me about it later. Thank you.
You're up next for Deep Tech, yeah.
So, okay, Deep Tech Innovation Lab. And I'm going to hand this one off pretty quickly to Matt. Matt's going to be surprised. I had to narrow the number of slides, so he's going to work through it. This is a class that's done law school, engineering school, and business school. Designed by Matt several years ago, and I was really excited about it because one of the new job types that's developed in Silicon Valley is a product counsel lawyer. And this is a lawyer that's embedded with teams, embedded with product development teams. So one day they're business people, one day they're lawyers, but they're there to apply the legal education and the discernment that lawyers are supposed to have. But they have to blend in with the legal team or with the products team. So it's a really interesting class to give you exposure to working with engineers and business people because they do not think like we do. And that's a good thing. That's what makes the team work well. But there's a reason there are so many lawyer jokes out there. It's because 75% of them are true and people don't want to work with us. You have to figure out how to build these teams. And when you talk about the successful product council in the Valley, it's those that actually help get a product out the door rather than say no all the time. And we're really good as a profession at saying no. But for product council, you have to figure out how to get to yes if at all possible. And that is a hard process. And it's actually hard for the business people and the engineers to figure out how to talk to lawyers. So the friction in that class between lawyers, engineers, business people is spectacular to watch. And then watch how they get to the end of the semester. So with that, I'll let Matt talk about the whole structure of the class.
Thank you. Thank you so much, Wayne. Hello, everybody. I'm happy to be here. I'm neither a lawyer, law student, business MBA, or an engineer. My background's in music, which makes me very qualified to teach a class at the intersection of business, technology, and law. So this class came to fruition. My father is a lawyer. He's a patent lawyer. He started a company in the early 1990s, which was the first company to convert all the world's patent information from paper to electronic format. There was a time when all patents were only in paper format, believe it or not. And once you had this database or this big data set of patent information in digital format, you could do things that were never possible to do before. So you could answer questions about the business issues, about the technology issues, about R&D issues, about legal issues, all in the context of the competitive landscape. So patent information can be used as a control position, a way to stop other people from doing X, Y, or Z, but it can also be used as a tool for competitive intelligence. We mostly focus on the competitive intelligence piece in our program. And the reason for that is because, as Wayne said, when you're releasing a deep tech innovation into the market, you need to understand what the business issues are, where the licensing opportunities are, who has the control positions to enable you to either partner with them or have to take a license for them. You have to understand the technology issues. What is my tech? How does it compare to other people's tech? And you have to understand the commercialization and the business issues, right? How am I going to bring it into the market? Of course, the regulatory, the data privacy, the intellectual property issues are also essential. And that's where you all come in. So what we've done, we'll see what these slides look like. Thank you, Wayne. We've created a partnership between the law school, the engineering school, and the Haas Business School. And we partner with actual real-world technology providers and producers. So we work with Berkeley National Labs. They've been our main partner for the last 6 years. We have recently started working very closely with Mitsubishi Electric. And then we have these sort of support partners that help run our program. Our program actually has its own operating budget. So it costs quite a bit of money because we have 5 mentors that we pay in the program, and then we have generous mentors from the community who volunteer their time, like Wayne, to help support us. Just to quickly double down on that, so this semester, for example, we have 15 projects from startups, from technology providers, and from research labs, corporate research labs, and we have about 12 mentors who are participating and embedding with our teams. Some of those are lawyers, some of those are engineers, some of those are founders, some of those are investors. And they sit on calls once a week, twice a week, that happen between the founders and our team of students. So we pair the students up into teams of 5 or 6, 1 law student per team, so we only have 15 spots for law students, 2 or 3 engineers per team, and 1 or 2 Haas business students per team. And the idea is that we give you a patent at the beginning of the semester. We introduce you to each other, we introduce you to the founder, we introduce you to a few mentors, and then you go. Okay? And we introduce these frameworks throughout the semester to help you understand how do we think about commercialization, how do we think about business model, how do we think about tech comparison, how do we think about intellectual property searching, how do we think about strategy for all these different things, and how do they all fit together? So the idea is to assess these technologies from a competitive point of view, analyze IP and regulatory issues, and explore the commercialization opportunities. We do this with real-world projects that could possibly end up in the real world, more likely some of the earlier stage projects end up being killed. And it's you guys that kill the projects. So at the end of the semester, you go and report out to your PI from Berkeley National Lab, and you say we did 300 hours of work throughout the semester as a team of 6. We did 30 customer discovery interviews. We looked at all these different potential application areas and ways to commercialize and the IP issues, and all this leads to there is nothing here right now. So we expect you to carry that message to these people. These are the people who invented these technologies, right? It's difficult. So there are lots of personal skills and communication skills that we train on, we mentor on. Our process starts with the introduction of the technology. So we introduce about 20 technologies on class number 1. You rank what your top 5 are, and then we have this magic algorithm where we assign you to an interdisciplinary team. 1 law student, a couple engineers, and a couple business students. We try to mix people up, people from different backgrounds, people from different parts of the world. We then, once your team is assigned, we start with patent analysis. You're literally given a patent, read it once, twice, 3 times to start to understand what the context of the technology is. We build these frameworks that we've built for the last 25 years with my colleague Bo Hayden from Gothenburg University and Chalmers University in Sweden. We do lots of expert interactions, both in class with our presentation nights where we invite experts in, through the expert networks, professionals that you're meeting, and through customer discovery. We actually have you call strangers and ask questions. Could be lawyers, could be business people, could be technology people. It doesn't really feel like a class. It's actually doing work for somebody else. The only problem is you don't get paid in money, but you get a lot of experience, and it's a differentiator on your resume when you go out and you talk to your, the law firm that you're going to apply to, and they say, tell me about a time you worked on an actual project, when you actually did something in school. Have you worked with business people? Have you worked with engineers? This gives you the baseline to start to have those conversations. What did you struggle with? What was the hardest part of working with a business student? Those are questions that you will have experience through our course to answer. I'm out of time.
Yeah, just about.
Okay.
Yeah.
20 technologies. We rank them in order. Interdisciplinary teams. Here's some prerequisites Wayne put up here.
No, this is for the next one.
This is the next one, sorry.
Yeah.
Okay. There was a, we take an application, so you have to apply to our course. There was a QR code that I can ship out to you that you can use to apply. Sorry to go over.
Oh, no worries. Thanks so much. All right, our next call is on Zoom. Yeah?
So if you're interested, ping me. I'll get you that QR code because you actually registered through HOS, but it's all set up.
Is it in the fall or in the spring?
In the fall and the spring. The
Hi, Adam.
Oh, okay.
fall program starts in August.
All right, great. So hi, everybody. My name is Adam Cole. I'm a senior associate at Wilson Sonsini in our patent and innovation strategy group. I'm here to pitch our patent prosecution class that we run that'll be offered in the fall. I co-teach the course with Michael Shallop, who's a partner at Van Pelt, Yee, and James. I focus primarily on life sciences and deep tech patent law and technologies. Michael is primarily a tech patent law lawyer. But we run the patent prosecution course is all about how do you get patents before the patent office. So we start with how to write a patent, how to write claims, what happens when you file a patent application, the process of getting from a patent application to a patent examiner looking at your patent application, dealing with communications from the patent office, often called office actions that more or less tell you reasons why you can't get a patent based on where your application's at, how you deal with those, how you talk to examiners during that process as a way to hopefully move your case along. It's called an examiner interview. We look at all aspects of patent law that come up in these types of actions. We do cover a little bit on the patent trial and appeal board. We have somebody come in who is a former PTAB judge and give a spiel on that. And then we wrap the course up with a little bit on freedom to operate. if you're interested in freedom to operate, the IP strategy and diligence course that we're running right now, my colleague Ali Al-Mozafar and I, that's going to get more into those weeds for those in the room who have already been in it. But we're only going to scratch the surface a little bit in patent prosecution. It's not a particularly demanding course. There are a few assignments throughout the course of the semester. And just like the IP strategy and diligence course, we teach it to be very practical so that students are able to get a sense of what it's like to be a lawyer in private practice, particularly in this type of work. We also split the class. There are sort of two tracks that a student can choose from. One is life sciences that I run, and we have an invention that we work with all semester. And then we have another track that's more of a tech-focused track. I'll call it a tech invention. And you can choose which of the two that you like to go on, and you work through using those inventions. So it's definitely helpful for folks to have some sort of technical background, although it's not required. It's definitely, I believe it's a prerequisite that you've taken at least the Intro to IP Law course that's offered at the law school to get you some of the very basics on patent law that'll be, I think, very helpful for doing the course. But it's meant to be a discussion. We don't tend to lecture for 2 hours straight. It'll be on Thursday nights, 6:25 to 8:15 once a week, and it's 2 units. Happy to take any questions if there are any.
So I think one thing that Adam's too modest to point out, this class has produced the most dominant competitive team in patent drafting in the country for the last 4-5 years, actually since the competition was launched.
Yes, that's right, Wayne.
This year's team is headed to DC to compete in the national finals next week. So whatever they're doing must be pretty good because they keep beating everybody else.
Yeah, it's something we're very proud of, and Michael, I believe he is the coach of the team and is the mentor. So for those of you who are have heard about it or have friends on it or have been on it, he's a really great co-instructor. So we're very excited to be teaching this course, and looking forward to having students in our class.
Great, thanks so much, Adam.
Yep, good to see you guys.
Perfect. All right, we're getting back on schedule. And next up is the Samuelson Clinic. Oh, no, sorry. Next up is Samuelson. Yeah.
Okay.
Yeah.
Where should I? If you're okay?
Yeah.
Great. Hi, everyone. I'm Eric Stallman. I'm the Associate Director of the Samuelson Law, Technology, and Public Policy Clinic that I run with my colleagues, Catherine Crump, Clinic Director, and Jennifer Urban, who's our Director of Policy Initiatives. I'm going to talk quickly about sort of the general areas that the Samuelson Clinic works in, some of the nuts and bolts of what we do in the clinic, and then as much as possible in terms of what I actually know and what I can actually tell you about what I kind of see on our docket for the fall semester. And then I'll leave some time for questions. So in terms of docket areas, I think our work falls into a couple of just sort of big pillars. The ones that I work the most on are intellectual property and telecommunications. And most of our work in intellectual property is in the area of copyright. We do some occasional trademark and design patent work. No member of the Samuelson Clinic is a member of the bar who can do utility patents. So we've done some patent policy work, but not patent prosecution or anything like that. We do a lot of work in privacy. Jennifer Urban is the chair of the advisory board of the California Privacy Protection Agency. And so there's just a lot of, she is very steeped in both federal and state and also European Union privacy law. And so we do some projects in those areas. A lot of work in civil liberties and work in the role of technology in the criminal legal system. That's a big part of our docket that Catherine Crump leads. I will say that Catherine Crump will be on leave next year, so I think that will be a smaller part of our docket in the fall and in the spring. And then increasingly, like everyone, artificial intelligence is just starting to creep into just about every area of our docket. We have questions related to intellectual property in artificial intelligence, privacy in artificial intelligence, and also we do some work just advising nonprofit organizations on their AI policies. In terms of the nuts and bolts of the clinic work, the first thing I want to just point out is that it's a big commitment, right? It's 6 credits total. 2 of those are a seminar where we talk a lot about issues that are common across the different areas that we work in. And also the second half of the semester, the seminar really works kind of almost like a practice group meeting in a firm or a meeting in an NGO on their work, where we sort of we workshop and case round issues that we're working on. The bulk of the work is the actual work on your clinic project, and that's a 4 credit commitment, right? That works out to an average of 16 hours per week, but life is not organized in weeks or semesters, neither are clinic projects, so the work tends to be bursty, which means there'll be some weeks when you do more than 16 hours, but we try to give that time back to you later on. But just I would visualize an average commitment of 16 hours a week on your clinic projects. That work, a lot of the work is really writing intensive. The clinic can satisfy the writing requirement. I can never keep straight which option it is, but it's one or the other one. 2. Okay, it's option 2. It can satisfy the professional responsibility requirement and, of course, the experiential learning requirement. Some of our projects may satisfy, I believe, the writing certificate requirement for the BCLT law and tech certificate, but that's something we have to work out with Wayne. The work that you do, the reason why we actually ask you to prioritize it is it's really important that you appreciate how much you take ownership of your project during the semester. You own the relationship with the client, you own the strategy on the project, and you own the work product. We are there, of course, to help guide you, to help you, take big swings and make mistakes. But this isn't a case where we're going to be doling out discrete little assignments to you for every week. It's when we're trying to help you take the lead in the matter, in all aspects of what the matter means. So that's why we ask you to prioritize the clinic work over the course of the semester. The fact that you're taking ownership, of course, doesn't mean that you're not being supervised or counseled along the way. We work with you really closely on your writing too. It's so essential to legal practice, no matter what you do, that we work with you intensively on your writing. But we really work to make sure that you are the person who is taking the lead on the drafting and seeing it all the way through. And then we also work with you on other matters representation, just sort of navigating issues with clients, sometimes navigating, I just came back from a rather frosty conversation with opposing counsel that some students were involved in, and sort of all of these things are things you will be dealing with in practice. And our number one goal, aside from serving the public interest, is helping you leave Berkeley law practice ready. And that is really a focus of all of our projects in the clinic, regardless of the different modalities of lawyering. And to be clear, not all of our projects are litigation projects. I would say, in fact, most are not. And one thing that we really try to help you do is understand that there are many different modalities of lawyering that are really important. So some of our projects involve agency advocacy. We have a couple matters with Federal Communications Commission right now. A lot of our works are just client counseling, where a nonprofit wants to do something that we think is a really good idea, but if they do it in the wrong way, they're in a lot of trouble. And so one thing that we really try to help organizations with is making sure that they keep their own procedures pretty clean when they're doing things like working with copyrighted works. Aside from that, we do a lot of policy advocacy, which is just trying to help organizations figure out the right way to intervene in public policy debates. In terms of the projects for this semester, or for next semester, I will say in happier times, most of my work is in the area of copyright. These are not happier times. Most of my work right now is different, either litigation or different interventions related to basically responding to actions by the Trump administration or agencies working on the administration's direction. We currently have one case where we're the lead petitioner in a multi-circuit litigation trying to challenge an order of the Federal Communications Commission that substantially increased the rates that incarcerated people and their families have to pay for phone calls and video conferencing in carceral facilities. We have another matter where we're helping organizations who are going to receive grants under the Digital Equity Act competitive grant program, only to see that entire program canceled after Trump issued an executive order. And so we're sort of helping them think through how to challenge that in an ongoing litigation. And then we're helping a bunch of different entities think through how to respond to another executive order that basically instructed federal agencies to request from states that participate in federally funded benefit programs, that they ask the states to basically hand over all of the personal information of applicants and participants in those benefit programs. And so we're helping them think through that too. So that's what I have on the docket right now, but I'm not, all of this is real life, so all of it may change by the fall, and so you just have to keep that in mind. If there's any time left, I'll take questions, but there might not be.
Might not be.
Okay.
Yeah. But
All right,
we are
great.
around afterwards. for
Yes,
questions.
yeah. Actually, I need to run, but if anyone has questions, estallman@berkeley.edu. Thanks.
And next up. No, not you. No. Sorry, I pressed down and not up. Bring it.
Hi, everyone. I'm Laurel Fletcher, and I direct the Global Rights Innovation Lab Clinic, which is one of the newer clinics here at Berkeley Law, although I've been here in another capacity for quite some time. So what we do in this clinic is, I like to explain it by saying, what do you need to win a case? You need the law, and you need the facts. And in today's practice, increasingly for high-impact work, those facts are in a digital format. And so you need to understand how you're going to marshal facts, how you're going to work with facts that are in a digital format. So in GRIL, what we are doing is we're taking multidisciplinary teams. So your law students, we want you to be law students. You're going to work alongside data scientists and data analysts to work on a case where the analysts are going to be doing the work of data science to identify patterns, practices, making connections that are otherwise undetected. Even though, going back to Wayne's example, you could do this laboriously, you cannot vibe code your way through this. You actually need experts in data analysis to do it correctly, but they can't do it on their own. They need to do it under your guidance. So that's the model at GRIL, that we are together building a different kind of standard for legal practice. So let me give you a couple of examples. When you think about an impactful practice, if you're at Berkeley Law, you're probably thinking about impact litigation, might be thinking about class actions, you might be looking at policy work if you want to do legislative advocacy. All of those are dealing with problems at scale. And so you're going to have data at scale that you need to marshal in order to persuade your audience. So we have, this year, we have been working with several clients. I'm going to flash, here is our project descriptions, and they're on the table in the back. We are going to be continuing with most of these clients in the fall semester, although these projects will be at slightly different stages. So if you're interested in any of these, the QR code is there and applications are due tomorrow. So for example, war crimes in Ukraine. Russian forces have been documented to have committed mass and systematic war crimes violations in Ukraine. We are representing an organization that has victims that want to bring prosecutions in foreign jurisdictions against Russian perpetrators for crimes against humanity. Crimes against humanity, you would need to know what those legal elements are. As the lawyers, you would research that. I will give you the answer. The two big things you need is to show that it's widespread and it's systematic. So what is evidence of widespread and systematic? The client comes with us with their data that shows that this is widespread or systematic, but it's a tangled mess. The data scientists untangle it. You're working alongside the lawyers because you're looking and doing the legal research to say, okay, this is what courts mean by widespread. This is what they mean by systematic. You're looking alongside the data scientists to say, okay, so what of this data actually speaks to those legal categories? And that interpretation, that discernment is the work of good lawyering. But it's garbage in, garbage out. The data scientists can analyze, but if they're analyzing the wrong categories, it's not going to be persuasive to a judge. So they're working together, and then we draft the legal argument. So the student team this week are putting the final touches on a fairly extensive submission that is going to be part of a larger submission that our client is going to file. And so what the students have done is taken probably your own intuition that if you have an invading army where you have reports of systematic war crimes, you're going to see that those track the troop movements and where there's territorial conquest. But you can't just go into court and say, like, that's just logical, right? I mean, you could, but you probably lose. We're coming in with the evidence that actually shows those patterns. And we have data visualization where you can actually visualize in the timeline and track the reported violations. So these become very powerful, very different kinds of interventions. And that's what I mean about we are taking legal practice into the digital age. So yes, take Wayne's class if you want to understand how to enhance your legal practice through AI. Come and do the clinic if you want to work alongside data analysts and figure out how you actually use that in a case, right? So it's a different, I think these are complementary, but they're different kinds of skills. So we're working on war crimes in Ukraine. We're working on gender apartheid in Afghanistan. We have about to finish a report on public floggings in Afghanistan. It is one of the ways that the Taliban regime is enforcing gender apartheid. And we are looking at that data and analyzing those patterns, and that's going to be submitted to UN human rights bodies. We're also taking that evidence and we're making it into visualizations for a public campaign to change the law, international law, and recognize gender apartheid as an international crime. So it's that kinds of translation of data into legal categories that speak to various audiences that we're doing in the clinic. We work on, a lot of the work is international, but some of it is also domestic. We worked on climate impacts in California jails. We're also looking at police accountability because there's a data set that's come online that tracks police misconduct records. And so how can we help individuals? How can we look at patterns for police misconduct? So we have a variety of projects, domestic and international. The descriptions are on the back. The applications are due tomorrow. Like the Samuelson Clinic, it's a 6-credit commitment. We encourage students to think about this as a year-long commitment because you will be happier if you can stretch out these really meaty projects over a year. And it gives you the opportunity to pick up a smaller project as well, so you have a fuller complement of legal skills that you can take. Your portfolio of work will be larger when you leave the clinic and talk to prospective employers. So happy to answer questions. If I've left a minute left. If I
Minute
do.
left, yeah.
A minute left. You've been talked into a stupor and into oblivion. Great. All right. So Laurel Fletcher, you can send me an email. Literature on the back. Happy to talk.
All right. And Peter, you're up next.
Well, good afternoon, everyone. I'm coming last, but I hope you've got a couple minutes to listen. We are living in an unprecedented stage of technological change and disruption in the copyright field. We've lived through multiple of these digital disruptions, from software to mobile technologies to the internet. And generative AI, as you've already heard today, you undoubtedly know, is one of those moments, and it's happening more rapidly than these prior disruptions. Currently, we are at an impasse societally, that the courts are having to deal with these cases that are really unprecedented. Congress has been moribund. The White House is not really acting in ways that are predictable and understandable. And we face an opportunity to try to optimize across our society, but no one is acting quite yet. The Copyright Office has been, I was just on the phone with the Register of Copyrights, and she's saying, yeah, I don't feel there's an opportunity right now to do much. And I said, well, it took 20 years to pass the 1976 Copyright Act. That's something we'll be talking about at our conference next week. And the DMCA, the Digital Millennium Copyright Act, came about in a somewhat shorter time frame and provided a foundation for what has been flourishing in both technology and copyright industries. We face that moment today. Companies like Anthropic, OpenAI, Google are all actively working in this area. So my idea for a way to enable students to get deeply involved in these questions is to build a seminar where we would simulate what a copyright reform process would look like. We use as the model, the template from the 76 Act and the DMCA. We build in the distinctive features where you'll have an opportunity to learn from people at these cutting edge companies. It just so happens that the chief legal officer at Anthropic was our student. He graduated in 2008. Their chief copyright attorney happened to be the editor of an article that I published about 9 years ago. And they were very excited when I proposed this. When I talked to the Register of Copyrights today, she says, yeah, we need to be moving forward on these issues. So the idea behind the seminar is that the first 3 weeks will really be kind of a boot camp on trying to understand everything that's going on technologically, in the courts, and internationally. Turns out, unlike, say, the DMCA and some other issues, the U.S. isn't leading in this area. We are leading on the technology, but other countries are moving ahead. And so my friend at Anthropic, who specializes in copyright, he's traveling around the world right now. He's trying to understand that process. So the idea is we'll spend a week going through all of these different institutions, and then we'll begin the simulation, where students will represent people within the Copyright Office who are involved in managing the process. People will represent the AI industries, and there are multiple AI components. They're not all the same. It isn't one thing. You have at least 3 different core communities. You have social media companies like X and Meta. You have the LLMs, Anthropic and OpenAI, and then you have the search engine company, Google. And so we'll have at least 3 people representing those different components. Then we've got all of Hollywood, the publishing industry, the newspaper industry, and people will be simulating those roles, and then we'll have sort of legislative Copyright Office people trying to manage it. We'll simulate hearings, we'll have some negotiations, we'll be bringing in lawyers from around the Bay Area who are involved in these different aspects. And the goal and the projects are really to give students an opportunity to work through some of the things that might happen in a clinic, but in a time frame that will enable you to see that whole process play out. The deliverables will be your participation and doing some writing along the way to advocate for the constituency you represent. And I will say this, I know it creates some concern by the administration. I encourage you to use AI. This is a class about AI. I want to see people optimizing how they use tools to try to understand this process. The final project, which everyone will do, will be out of role, where we'll step back and everyone will write a reflection on what they see as the ways to potentially address what is undoubtedly the most important set of issues in the history of copyright law. So I hope you'll join us. I want students from a broad range of perspectives. I don't want everyone who wants to work at OpenAI. I want students who want to work in all of these different components so that they can experience in a collaborative way the learning that comes from advocacy and trying to solve difficult policy problems. I'll also just do a pitch for our conference next week. The Copyright Act of 1976, still our modern act, was a similar clash. And hearing that story and working through those issues, I think will help you in building your radar as a lawyer, your ability to solve difficult problems. So I'm around if anyone has any further questions, but I hope I'll see some of you next fall.
Thanks, Peter. All right, I'll close this off. I will just say, as someone who was in your shoes not long ago, I took one of, Peter ran a trademark equivalent of this, and it was probably my favorite class that I took in law school. And I did not really think I would be that into trademarks, and it became really, really useful as a practicing attorney. That's just a point also for a plug, also for just real life practical experience in classes. All right, so I will just note, I'll close this off by saying, we offer our BCLT certificate, and more likely than not, if you're in this room, you will probably be able to qualify for it. This is all online too, and if you ever need help kind of getting mentored through, like what sequence of courses should I take, you can always plug in the time on my calendar and I can walk you through it. My big note to you is just to really lean in on things. I took some big swings when I was in your shoes, and I did some projects that I was a little bit hesitant on, and I thought, I kind of want to have a 3 LOL, and I don't really want to do much, or I kind of wanted to have a 2 LOL, and I didn't really want to do much. And I kind of felt guilty, and I was like, all right, I'll do this, or I'll do that. And those things that I did ended up being career defining for me. They really set me on an important path. It might be really fun to, get caught up on Top Chef next year, but I will say you're only in law school for 3 years. Do the hard things. Do things that are going to be really cool deep dives, and I do not think that you will regret it. Great. We are around for the next hour in this room. For anyone who has individual questions, I can take, actually, we have 4 more minutes on the clock. Any particular questions from anyone in the audience? Yeah. There are, to my knowledge, no more prerequisites for any classes. And we do not presume it. It is nice to have taken IP, but it is, we can get you there if you haven't. And also, a lot of the LTWW things that we do are not really in the realm of traditional IP buckets. Sometimes students will write notes that don't really touch on patent, trademark, copyright, or trade secrets. Yeah.
So, a year and a half ago, last cycle, I supervised ITAR. You know what ITAR is? Neither did I. It's basically international regulations on weapon exportation. So it was looking at AI for weapons and how that fit into ITAR. Patent law is not going to help you with that one. Fascinating. I loved it, but I had to do a lot of reading to keep up. So that's kind of the variance you'll see.
Yeah, this is also just typical recommendation. I think that you should take Intro IP as a student here. It's a cool class, and not a lot of universities offer that. Often you have to take all of those individual courses, which can be quite annoying. It's really great, and we have really great people teaching it here, but it is not necessarily required for a lot of these classes, and IP is not tech. Those are different realms. Yeah. Yeah. Yes, so I didn't put it on here because we didn't have time, but I am teaching a topics in health law class next fall, and I hope people take it. Yeah, it's coming up this fall. And we'll cover all of the new big pressing topics in health law, and students will write policy briefs for that. And we're going to publish those on our website. So just a plug for that. I didn't want to take time from the other speakers, but yes, please do take it. I think it'll be a really, really great class. And my big goal for that is to get you to have a thing that has your name on it that you have become an expert on for the semester. I think that'll be a really fun, interesting class. All right, we got about 2 minutes. Wayne and I will stick around. Happy to answer any questions that come up. Thanks to everyone for stopping by.